Majority Report with Sam Seder.
The destiny of America is always safer in the hands of the people than in the conference rooms of any elite.
Sam Seder.
They are unanimous in their hate for me, and I welcome their hatred.
We must guard against the acquisition of unwarranted influence, whether sought or unsought, by the military-industrial complex.
The Majority Report with Sam Seder.
And I get the feeling you've been cheated.
It is Tuesday, April 23rd, 2024. My name is Emma Vigeland, in for Sam Seder, and this is the 5-time award-winning Majority Report. We are broadcasting live steps from the industrially ravaged Gowanus Canal in the heartland of America, downtown Brooklyn, USA. On the program today, Randall Eliason, law professor at GW, former assistant U.S. attorney, will be with us to break down and explain Trump's numerous legal battles, including the one happening as we speak. Also on the program today, it is Election Day in Pennsylvania, folks. There's a write-in campaign for uncommitted under the presidential column. Summer Lee also faces an AIPAC primary challenger. Opening arguments started in Trump's hush money trial yesterday. The prosecution alleges Trump has already violated his gag order. Again. Biden takes a narrow lead versus Trump amongst registered voters in Marist's latest national poll. Pro-Palestine college protests swell. Faculty at Columbia and NYU join their students, some even getting arrested. Tom Cotton calls for the National Guard to be deployed on these students, echoing Kent State deliberately. International alarm grows as Israel presses to invade Rafah. Bombings in Rafah over the past few days have killed dozens, mostly women and children. Weapons spending worldwide hit a 35-year high last year. $2.4 trillion, with the U.S. spending more than a third of that. And the Senate will vote today on Ukraine, Israel, Taiwan funding, as well as a TikTok ban. Biden alongside AOC, Bernie, and Ed Markey announced $7 billion in solar subsidies on Earth Day. More new White House rules include imposing a staffing minimum for nursing homes and barring the release of abortion-related health records for women. The FTC is expected to approve a rule banning requirements for workers to sign non-competes, as well as blocking a Coach Michael Kors fashion merger. The Supreme Court appears poised to uphold an Oregon city ban on homelessness, basically. They're hearing Starbucks' challenge to the NLRB authority today. Tennessee Republicans' charter voucher bill fails, preventing a gutting of public schools. And lastly, UK Prime Minister Sunak has approved a bill that removes all migrants coming to England to Rwanda without any assessment of their asylum claims. All this and more on today's Majority Report. Welcome to the show, everybody. Sam is out this week on vacation, celebrating the holiday. It is a Newsday Tuesday. I am here with Matt and Bradley. Hello to them, and hello to you. Hello to the New York Knicks and the rest of this city and everything. Bradley's wearing the hat. We'll get into that on ESPN. I won't bore everybody with that, but oh my goodness. It's 30 years since 1994, and the city kind of feels like it. So some exciting sports times in New York, but I will not get ahead of myself because I'm afraid of the whole jinx situation. We'll start here before we speak to Randall Eliason, who is a legal expert who blogs a lot about Trump's various legal issues. And we'll talk here about the Supreme Court, which is deciding in a case called Grant Pass v. Johnson. They heard oral arguments yesterday. They're deciding whether this city in Oregon, Grants Pass, which is roughly 40,000 people, there's no homeless shelter in the city in southern Oregon. They're deciding whether or not to uphold this ban on people basically being unhoused. And I'm not exaggerating there. It makes it a civil violation to sleep outdoors. And this is the definition of criminalizing poverty and putting people in a cycle of poverty, because it's not free, FYI, to have dealings with the criminal justice system, especially with civil penalties.
And let's just remind everyone that the political class is owned by real estate, who are actually the culprits for why people are homeless in this country.
It's housing shortages, right? And so where are people going to sleep if they don't have a home? They may sleep in a park. They may sleep under a blanket. And at issue in this case is the Eighth Amendment's prohibition on cruel and unusual punishment, which I think is apt here. But unfortunately, this Supreme Court has gutted the Eighth Amendment for quite a while, and Clarence Thomas in particular has shown a deep love for things like capital punishment. But this happened a few years, this case, after there was already some litigation surrounding homelessness in the Ninth Circuit, which encompasses California and Oregon. In Martin versus City of Boise in 2019, the Circuit Court of Appeals there did not allow to criminalize camping law for homeless residents. And they basically said that some of those ordinances could not be enforced. And the Supreme Court, after that, declined to review the decision. And that's where the law basically stood up until this point, when the Supreme Court decided to take this case up. So the liberal justices were immensely skeptical, as was Amy Coney Barrett a little bit, which gives us a glimmer of hope. But you need more than one conservative based on this construction of the Supreme Court, and I'm not sure they're going to be able to get somebody. Regardless, here is Sotomayor in oral arguments yesterday expressing that skepticism, questioning the attorney for Grants Pass, Theani Evangelis. Thean, I don't know how to say her name, but this is what Sotomayor was asking about.
Assuming it's there, it prohibits you criminalizing homelessness, right? So what you do is say only homeless people who sleep outdoors will be arrested. That's the testimony of your chief of police, two or three officers, which is, if you read the crime, it's only stopping you from sleeping in public for the purpose of maintaining a temporary place to live. And the police officers testified that that means that if a stargazer wants to take a blanket or a sleeping bag out at night to watch the stars and falls asleep, you don't arrest them. You don't arrest babies who have blankets over them. You don't arrest people who are sleeping on the beach, as I tend to do if I've been there a while. You only arrest people who don't have a second home. Is that correct?
Well,
who don't have a home.
So, no, these laws are generally applicable. They apply to everyone.
That's what you want to say. Give me one example, because your police officers couldn't. And they explicitly said, if someone has a home, and is out there and happens to fall asleep, they won't be arrested. Fall asleep with something on them.
Well, Joint Appendix, page 98, is one example of a citation issued to a person with a home address. But more importantly, I think what we're getting at here is that these laws regulate conduct of everyone. There's nothing in the law that criminalizes homelessness. I really
That's what you say, but if I look at the record and see differently.
Yeah, I mean, she makes a very compelling point there, which is essentially that if you are clearly of a class that has a home and has private property or is a renter, you're like Sotomayor and you take a nap on the beach, or even say you're sunbathing in a public park in the summer and you fall asleep. I've done that. Then am I going to get arrested in the same way that a person who's showing that they are visibly unhoused would be? Of course not. And the fact that this lawyer was trying to assert that there wasn't a double standard in this instance is ridiculous.
To be coy. They're being coy. I
Yeah.
mean, this is a lock up homeless people bill.
It is.
Own it.
Catfish James writes in, small correction on Grants Pass v. Johnson. There is a private homeless shelter there that requires church attendance and labor to use it.
Oh, that's wonderful.
Well,
it requires church attendance? Beautiful.
That's why I didn't really include it, because it's also categorized as a religious, quote, transitional housing program. I wouldn't categorize that as a shelter, to be honest with you.
I mean, George Orwell wrote he did Down and Out in Paris and London, where he went around as he called it at the time, a tramp, and went through the humiliation that unhoused people go through in religious contexts, needing to like put up with just bullshit to get fed.
Well, I mean, right, exactly. It's you have to show fealty to the religion. You have to basically be docile, and that's not a way to treat a human being. I mean, it's humiliating, and that's the kind of thing that and there's also all these hoops to jump through and requirements often for testing that first the number one thing we need to be focused on is alleviating the exacerbating factor here, which is being unhoused, contributing to mental health episodes tangibly as well as active addiction, and then you can work on those issues and getting people back up on their feet. But Mark Joseph Stern, as always, has a great write-up in Slate and explains further what the Supreme Court is looking at here. Since 2018, the Ninth U.S. Circuit Court of Appeals has held that the Constitution prohibits the prosecution of indigent people who sleep in public places when there is no available shelter space. That's the case that I referenced earlier in the Ninth Circuit. Yes, the Ninth Circuit. Grants Pass gives the Supreme Court an opportunity to overturn that rule, and in the process roll back long-standing limitations on cruel and unusual punishment. A majority of the court seemed inclined to do so based in part on a suspicion that the Ninth Circuit somehow is exacerbating homelessness. Which, by the way, the implicit argument here, this is me editorializing, is that it's incentivizing it? Oh, because you say people can sleep in public under a blanket, they're going to all want to.
This is money, too, to prison systems.
Yes. Yes. And Mark says, let's be clear, it isn't. And abolishing the Ninth Circuit's narrow ruling will do nothing to help people who lack housing or the communities in which they reside. The appeals court decision was rooted in the 1962 Supreme Court case called Robinson v. California. In Robinson, the High Court struck down a California law that criminalized addiction to narcotics. The disease of addiction, the majority reason, constituted a status that the government may not penalize under the 8th and 14th Amendments, which prescribe states from imposing cruel and unusual punishments. The act of using narcotics could, of course, be prosecuted, but a person's mere condition as a drug addict could not. Based on this precedent, the Ninth Circuit ruled that homelessness, like addiction, is a status that Grants Pass could not lawfully punish. And sleep, far beyond being a voluntary act like narcotics use, is a basic human need that unhoused people literally cannot live without. So there's the second layer there that should undergird this reasoning and basically say that Robinson applies and that the Ninth Circuit ruling should stand, because sleeping is not in the same legal status as narcotics use, which is illegal. But addiction's not illegal. Homelessness is not illegal. The second standard beneath that should also, again, make this case stronger. But that's not seemingly what the conservative justices are alluding to. Advocates for homeless people were alarmed when the Supreme Court agreed to review the appeals court's decision, given the conservative majority's extreme hostility towards the Eighth Amendment. SCOTUS has torn down pretty much every safeguard against cruel and unusual punishment that it has come across, eviscerating the principle that the amendment enshrines evolving standards of decency into constitutional law. The real question in Grants Pass, then, is not whether the Supreme Court will side with the town. It will. This is what Mark says. The question is how much damage it will do to the Eighth Amendment along the way. So Elena Kagan, Supreme Court Justice, also made the case that I was just making in oral arguments about how sleeping is not something that's voluntary or an action that you can take that should be deemed a criminal activity. But to bring it back to what I said before, this is a way to further push people in a cycle of poverty and into the prison industrial complex where they're going to have to pay fines over and over again for their own poverty and the conditions that society has set for them.
And yeah, I mean, I think Luke O'Neill's talked about this with regards to like police locking up people in Chicago. Like if you lock up somebody from downtown Chicago and they are transported to like a suburban containment facility, prison, that not only means money to that facility and not basically for caging a human, but also counts for them on the census. And I imagine this would probably play the exact same way. That okay, we get we sort out all the developers who want the police to remove homeless people. We get more money for prisons and count it towards the suburbs on the sentence. This is all part of the system.
Quick break, and then we will be getting to our guest, Randall Eliason. But first, a word from our sponsors. Have you wanted to learn a language? You know, I have. And the best way to do so is immersion, living where the language is spoken and using it every day. But if that's not in the cards this year, you can still learn a language the second best way, and that is with Babbel. And, you know, I really struggle with languages. I've used Babbel a bit, and it's a lot more intuitive and easy than I anticipated. And you're able to kind of pick up quick phrases that are really useful for you right off the bat, or fairly early on, at least for me, especially because languages don't really come naturally to me. Be a better you in 2024 with Babbel, the science-backed language learning app that actually works. Don't pay hundreds of dollars for private tutors or waste hours on apps that don't really help you speak the language. Babbel's quick 10-minute lessons are handcrafted by over 200 language experts to help you start speaking a new language in as little as 3 weeks. Babbel's designed by real people for real conversations. Babbel's tips and tools are approachable, accessible, rooted in real-life situations, and delivered with conversation-based teaching. That's what I was alluding to. It's true. So you're ready to practice what you've learned in the real world. Studies from Yale, Michigan State University, and others continue to prove Babbel is better. One study found that Babbel for 15 hours is equivalent to a full semester at college. Babbel has over 16 million subscriptions sold, plus all of Babbel's 14 award-winning language courses are backed by their 20-day money-back guarantee. Here is a special limited-time deal for our listeners. Right now, get up to 60% off. 60% off your Babbel subscription, but only for our listeners at babbel.com/majority. Up to 60% off at babbel.com/majority, spelled BABBEL.com/majority. Rules and restrictions may apply. And lastly, one of our favorite sponsors, Liquid IV. You know, in the summer, you want to maybe go for a run, go to the beach. Tough to stay hydrated, and you can lose track of your hydration really quickly when you're exercising or when you're just out in the hot sun, in the air, working out. And Liquid IV is helpful for that. Maybe you want to have a few drinks, and in the morning you want to hydrate yourself, or at night if you're being very forward thinking about it. Liquid IV is perfect for that. With that summer feeling running wild, you need hydration that keeps up with every moment. A single stick of Liquid IV makes ordinary hydration extraordinary. With 3 times the electrolytes of the leading sports drink, plus 8 vitamins and nutrients for everyday wellness. Liquid IV is a staple in my house. It's a staple here at the office. Sam drinks it every single day. I drink it most days, honestly, before the show, because we have so much of it, and it's so easy and a great way to start your day with hydration. And they have awesome flavors like pina colada, the strawberry I love, lemon lime, gosh, I'm trying to think off the top of my head what the other ones are. I remember them by color. Yeah, there's tangerine, everything that you could want. It has 3 times the electrolytes as the leading sports drink. Liquid IV is the #1 powered hydration brand in America. Just tear, pour, live more. 1 stick plus 16 ounces of water hydrates better than water alone. Liquid IV contains 8 vitamins and nutrients. It's non-GMO and free from gluten, dairy, and soy, and it has no artificial colors or sweeteners. Check out their 4 delicious sugar-free flavors: white peach, green grape, raspberry melon, and lemon lime. It's a zero sugar hydration solution with no artificial sweeteners and clinically tested to hydrate more than water alone. Turn your ordinary water into extraordinary hydration with Liquid IV. Get 20% off your first order of Liquid IV when you go to liquidiv.com and use code MajorityRep at checkout. That's 20% off your first order when you shop Better Hydration today using promo code MajorityRep, one word, MajorityRep at liquidiv.com. Thank you, Liquid IV, for your support. All right, folks, quick break, and when we come back, we'll be speaking to Randall Eliason. We are back, and we are joined now by Randall Eliason, professor of white-collar criminal law at George Washington University Law School, former assistant U.S. attorney for the District of Columbia, where he served as the chief of public corruption, government fraud section, and author of the blog Sidebars, where you can get all this up-to-date legal information on Trump and more. Randall, thank you so much for coming on the show today.
Sure, my pleasure. Thanks.
So we had a viewer write in last week and saying that they're having a bit of trouble keeping track of Trump's various legal battles because there's a lot. And they would love if we had an expert on to discuss this. So you were the man to call. How many indictments are we currently at right now with Trump, numbers wise?
So, and it's not just the criminal matters, of course. There's the civil matters that are in the news a lot as well, like the civil fraud judgment and the huge bond he was required to post and things. But the criminal cases, there are four. Four criminal and one in Florida. And then two state cases, one in Georgia and the one in New York, of course, which is actually gone to trial and going on right now.
Yes, the one going on right now, it's literally as we speak. Yesterday was the first day of that hush money case, that hush money trial. We're in day two, or not maybe the first day. It was the first day of oral arguments. I apologize.
Right.
What did you observe on yesterday when oral arguments opened up?
Well, I don't think there were any big surprises. I mean, the case, the actual criminal charges are not terribly exciting. They're kind of a bookkeeping charge. It's about keeping false records in the internal records of the Trump organization, 34 different counts of that, where the state claims that they recorded these expenses as legal expenses, payments to his attorney, Michael Cohen, when really what they were for were not legal expenses, but to repay him for the hush money payoff to Stormy Daniels. So the kind of big picture is the state's argument that this was all a conspiracy to cover up the hush money payment that was made right before the 2016 election, which was to try to influence the election, keep that damaging information away from the public. But the thing is, the hush money payment itself is not a crime. There's nothing illegal about that. So they it's almost like this judo move. You know, they take what's actually kind of a boring and technical charge of false business records, but the reason he did that was to conceal this hush money payoff scheme. And so they actually characterized the case as being about election interference or election fraud, that this was really all about trying to manipulate the 2016 presidential election. And these false records are just a sort of sign of that, or one way to try to continue that cover up, even though the records were actually made after the election. So the records themselves couldn't have, defrauded any voters or influenced the election at all.
Well, you actually, I read one of your articles on your website, Sidebars, and you made the point that you feel like the election interference piece of the prosecution's arguments maybe not the strongest. What's your reasoning behind that?
Just sort of what I said. it's a way to characterize the case, kind of the atmospherics. That's the way kind of they're portraying the case to the public. But legally, it's really not. This really is not about election interference because, like I said, the false records that actually form the basis of the actual criminal charges, they were all made after the election was over. So how do they interfere with an election at all? And even the hush money payment itself, well, that was to try to keep damaging information from the voters. Sure. So they were trying to influence the election, but politicians do that all the time, right? Politicians are always trying to manage damaging stories and keep them from coming to light and things like that. And it was not otherwise illegal. So now is every time a politician tries to keep some damaging story out of the news, is that election fraud or voter fraud, election interference? So I feel like the way the public portrayal of the case, or the prosecutor's kind of theme of the case and saying, oh, this is really about election fraud, so the kind of way to kind of dress up what's otherwise a kind of boring and technical charge of, making false records and make it sound more significant than I think it actually was.
So there are those three pieces, right? The violation of federal campaign finance law, the violation of state campaign election law, and then the violation of state tax law. So your assertion really is that it's that third piece that has the strongest case. The
tax law?
Yes. Yeah.
Well, yeah, I don't think any of them. I mean, so those are the three laws to make this charge a felony. As you know, the state has to allege that these business records were falsified in order to conceal some other crime, and that otherwise it's just a misdemeanor. And so what they alleged before trial was that there were three other crimes that they were actually trying to conceal. One is a federal election violation, illegal contribution to the Trump campaign by the payoff to Stormy Daniels. The second is a state election law violation, and the third is a state tax charge. Yesterday, they seemed to emphasize primarily the federal election charge. They didn't really talk in the opening statements about this state election charge or the taxes. But I mean, they could still come back to that. But they've got alternate theories about, what the underlying crime is that they were trying to cover up. And again, they don't actually have to prove that crime was committed. They just have to prove that the intent to conceal that possible crime was part of the motive for falsifying these records.
Randall, you cut out briefly. Not sure if you can hear me. Oh, just you briefly cut out, so we didn't get really the end of your sentence there. But my question really to you is, are they going for the federal election, opening with the federal election angle, basically, because Michael Cohen has already served time and confessed to crimes in this area?
Yeah, I think that's probably a good part of the reason. They feel that's their strongest theory, I think. And like you said, Michael Cohen already pleaded guilty to basically the same crime. So although they don't have to prove that Trump committed the crime, that's probably the easiest thing for them to hang their hat on when they're trying to say there was this other crime that they were trying to cover up by falsifying these records.
Right. And yesterday, the prosecution's leadoff witness was David Pecker of the National Enquirer. And you said early on in when we were speaking that hush money payments in and of themselves are not necessarily crimes, because there's the Karen McDougal piece that I'm wondering if you could expand on. It's the falsification of the records that constitutes these charges.
Right. I mean, the catch and kill scheme, as they call it, buying the rights to a story and then deciding not to publish it, that's perfectly lawful. I mean, it's a contract. I can buy the rights to your story, and then it's up to me what I want to do with it, including if I want to bury it. So there's nothing illegal about that. But the crimes related that Cohen pleaded guilty to related to considering those catch and kill payments to be campaign contributions. So the McDougal payoff by Pecker and National Enquirer, that was alleged to be an illegal contribution from a corporation. And then the Stormy Daniels payoff from Cohen was alleged to be an illegal contribution from Cohen that exceeded the lawful limits. So both of these schemes were portrayed as crimes, not because the scheme itself is illegal, but because doing it to further Trump's presidential ambitions was considered a contribution to the campaign, and so therefore needed to be reported or couldn't be made by a corporation. And that was the criminal hook.
And the 34 counts, is that because that was made to Michael Cohen in dozens of payments? This is spread out to falsify it?
Right. They took the payment so he made the payment to Stormy Daniels out of his own money. He took out a home equity loan for $130,000 and wired that. So they were paying him back. So it was that $130,000. There was another $50,000 that he had paid to a consulting firm or a polling firm. I think during the election they were reimbursing him for that as well. They tacked on, they called it grossing up, a bunch of extra money because he was going to have to pay taxes when this money came to him, purportedly for legal fees. It was going to be income, and he'd have to pay taxes on it. So they added another $180,000, I think it was, to help him cover his tax bill, and then the rest was a bonus, just a bonus to him, $60,000, I think. So the grand total was $420,000, and they said, well, we'll pay you that monthly, $35,000 a month for the next year. And so every month, Cohen sent them an invoice saying, here's my bill for legal services rendered pursuant to our retainer agreement. Well, there was no retainer agreement. And the state's arguing there were no real legal services rendered, although it sounds like the defense is going to claim that there were, and that these were actually legitimate payments, for legal work. But so it was monthly invoices and monthly checks and monthly recording of the payment in the ledgers of the Trump organization as legal services, which the government says was false. So every month you've got 3 different records, except for the final month. A couple of them weren't made for some reason. So they ended up with 34 counts, three a month for the 3 different ways these payments were falsely recorded in the Trump books.
What's your, after this first day of oral arguments, what's your assessment of the prosecution and how they performed?
Well, of course, we can't see it, right? We're at a little bit of a disadvantage with no cameras in the courtroom. I mean, it doesn't sound like any surprises, like I said earlier. And I think the state has a strong case on the facts. I mean, the documents case like this, they tend to speak for themselves. The documents say what they say. And I think it's going to be pretty clear that they were false. I mean, the defense really, from their openings, the defense opening was a little more surprising to me than the prosecution. I thought the prosecution was kind of what we expected. This was really about election fraud, election interference, and that's why they falsified these documents. Stormy Daniels is lying, Michael Cohen is lying. The records really were for legal services. That's a pretty aggressive approach. They could have said, well, yes, he was trying to conceal this, but that was because he was trying to protect Melania, or he'd wanted to avoid public embarrassment, but it wasn't really anything to do with election interference. They could have taken a more compromised approach and try to convince the jury that really this was just maybe a very technical violation, but no big deal. But they're going all in, and they've got to say everybody's lying. And that's pretty difficult for the defense, because the case is not going to rely just on Cohen and Stormy Daniels. There's going to be a lot of things that back them up. Other witnesses, other documents, and then the records themselves. So I think it's an uphill battle for the defense. I think the states, on the facts, like I said, have a strong case. I think there are some legal potential issues with the case, and that I've written about on my blog, but those most likely won't show up until there's an appeal if he is convicted.
Can you expand on some of those issues that could potentially crop up if he appeals?
Yep. I mentioned earlier, I think there's a question. So even to make this a misdemeanor charge, the state has to prove intent to defraud. And I think there's some question about how these are purely internal records of a private company. So these aren't submitted to any regulatory agency. They're not filed in public filings like a publicly traded corporation files at the SEC, anything like that. It's almost the equivalent of making a false entry in your own checkbook register at home, right? No one else has a right to see it. So how do you prove that that was made with intent to defraud anyone? And especially, how was it made with intent to defraud the voters when the records weren't made until after the election was already over? So it's kind of this convoluted, after-the-fact cover-up theory that just in case anybody did come looking, like the Federal Election Commission 2 years later comes looking at the records, or someone else, other investigators, well, we'll have this phony paper trail to help cover it up. That seems to be the state's fraud theory. There don't seem to be really any cases in New York that support that, although former members of the district attorney's office say they think it's common, that it's not unusual. But the fact that the records are purely internal, no one else had a right to see them, and they weren't submitted to anybody else, I think makes intent to defraud a challenge, even for a misdemeanor charge, much less a felony charge.
Well,
and there are other issues as well, such as, can a federal election crime be the basis of this state criminal charge? That's one thing the defense has challenged. The judge for now has ruled yes, but it doesn't appear that the higher courts in the state have taken a firm stand on that yet. And there's a question of even was this an election crime? The John Edwards back in the day was charged with something very similar, and the jury failed to convict him. I mean, experts don't necessarily agree that this was, in fact, this should have been considered a campaign contribution. And if it's money from Trump himself, he's allowed to give unlimited money to his own campaign. So I just feel like the charge itself is very technical. Like I said, it's kind of a bookkeeping charge. And they've really tried to dress it up and call it an election fraud case. And I just don't know if that's going to hold up in the long run.
I think your analysis, even though it's not necessarily maybe what exactly we want to hear, is accurate or compelling. And my question to you, though, is this civil fraud. I read today in the Times that the prosecution was able to either ask Trump about the civil judgment against him or basically include that within the scope of the case. Because he was found liable for hundreds of millions of dollars in that civil fraud trial just some weeks ago, does that add to the prosecution's ability to make a case that this is a part of a larger kind of fraudulent effort by this corporation and by this person?
Sort of atmospherics-wise, yeah, I think that's right. But legally, it's a very different set of circumstances. The fraud in that civil case had to do with defrauding insurers and bankers, by inflating his assets and saying they were worth far more than they were to get loans or to pay lower insurance premiums. But there you're actually, giving the documents to someone. You're giving the information to someone, intending for them to rely on it. That's usually what fraud means. Unlike this case where the documents...
Oh, I'm sorry. I think we lost Randall briefly. 1 second. Oh, we lost Randall right in the middle of this sentence. Okay, all right. We will be back in 1 second, folks. Sorry about that. Taking a quick break. Sorry about that, folks. We're back with Randall. So you were mentioning that I had asked you a question basically about how the civil fraud judgment could play into the arguments in this case.
Right. And I think, as you suggested, it contributes to kind of an atmospheric argument that the fraud is part of his life, right? This fraudulent organization and lying is kind of standard business practice. But legally, it really doesn't affect these charges because the civil fraud case involves documents that were actually submitted to insurers and bankers, intending for them to rely on them, that the states had inflated his assets. But that's fraud, right? You give someone a false document intending that they rely on it. Unlike the documents in this case, which were, like I said, purely internal, that no one else had a right to see and weren't submitted to anyone for the intent to defraud. So it's a very different kind of allegation. And then the ruling you're referring to, there's a pretrial ruling. So normally if a defendant doesn't testify, the state isn't allowed to introduce evidence of all the other bad things they might have done. just to try to suggest to the jury, well, they're just basically a bad person, so they probably committed this crime as well. That's not admissible. But if they take the stand, then all of that stuff comes in, because the state can then cross-examine them to challenge, in this case, Trump's credibility with evidence of prior bad things he's done, and including the E. Jean Carroll verdicts and the finding of sexual assault and the finding of civil fraud. So there's a pretrial hearing where the judge rules on whether those prior bad acts can come in or not if Trump testifies, because then that allows the defense to factor that into their decision about whether he should testify or not. So if he were to take the stand, then the civil fraud case and the E. Jean Carroll case and those other things would come in. But I think he's extremely unlikely to take the stand, even though he's saying he will. That would be, there's not a defense lawyer alive that I can think of that would think that's a good idea.
No.
Now, ultimately, it's his decision ultimately, and he could just refuse to follow his attorney's advice. But if he takes the stand, it'll be the best thing that could happen to the prosecutors.
Well, I mean, it's also you alluded to some of the strident arguments made by his defense team. I mean, we're not talking about the top lawyers in the country at this point, right? This is he's had some difficulty retaining people given his proclivity for not paying his legal bills or any bills.
Yeah, that's true. Although I think his lead counsel in this case is a pretty respected attorney,
okay.
but he's got it's not the Rudy Giuliani, it's not the or Sidney Powell crowd, but he's got a tough client on his hands, and he's got a tough case.
Yeah. So I guess then I wanted to turn to the other cases and the statuses there. We were talking about the civil fraud case and the judgment, and I know Letitia James is challenging the validity of his bond in the civil fraud case. What's your assessment of where he's at? I mean, and his ability to pay, and how that bond plays into the outcome.
Yeah, I saw a headline just before he came on that it sounded like they'd reached some resolution.
Okay.
I haven't followed the civil stuff as closely, but it sounds like they've come up with some additional conditions that he'll agree to that will allow, and the state will then accept the bond. So maybe they've got that figured out, but I don't know all the details yet. But again, that's just to allow him to appeal, basically, right?
Right.
Just has to post the bond so that he can appeal the civil judgment. And, I don't think it would be surprising to see that total judgment be reduced on appeal somehow. But the bond, it sounds like maybe they've resolved.
But I mean, this may just have escaped my memory, but given the amount that he basically was found liable for, that he has to pay back, the hundreds of millions of dollars, why were criminal fraud charges not pursued against him?
Well, that's a great question. I mean, and it was somewhat controversial. The former DA in New York was reportedly ready to bring this as a criminal case. And then when Alvin Bragg was elected, he chose not to bring it. And you might recall there were a couple of prosecutors who resigned from the office kind of in protest. They thought the case was all ready to bring. And then Bragg said, no, it's not ready. We're not going to do it. So I think a number of outside observers have asked that same question. It's like, why wasn't this the criminal case that you brought? This looks stronger. Now, as a former prosecutor, I'm always hesitant to second guess those judgments, because from the outside, we know only a relatively small portion of the relevant information, right? So much of what goes on in a criminal investigation is protected by secrecy. And so there might have been factors at play that we just don't know about that led to that decision. So I said, I'm always a little reluctant to second guess a prosecutor's motives in a situation like that. But it's certainly and we don't know, so we still don't know really the answer as to why Bragg declined to bring that case and then went back and resurrected this one, which most people think is far weaker. And this was the criminal case that he ended up bringing.
And the two federal cases, the classified documents case and the January 6th case. I know the documents one is further along. Let's start there. What's the status and some of your observations of that?
So the federal case in Florida is the documents case. That's based on the unlawful retention of the classified information at Mar-a-Lago, right? The boxes of records that were kept in his bathroom. and then hidden from investigators when they tried to recover them. Of all 4 cases, that's probably the strongest one. I think it's pretty open and shut.
Right.
You're just not
just
allowed
like
to
the
have...
bathroom door. Just like that bathroom door.
You're not allowed to have this stuff. And especially when they come asking for it repeatedly and you fail to return it, even if you thought initially you had a right to have it, when they ask for it repeatedly and you refuse to return it and then try to hide it from them, there's just not much in the way of a defense there. So, it's very different from finding a few stray classified documents in Joe Biden or Mike Pence's files that they didn't even know about, and they immediately return when they're found, right? I mean,
right.
This really is primarily about the obstruction and the repeated refusal to turn them over. It's not about having the documents in the first place, although the quantity of documents here is absolutely, and the deliberateness with which they were taken is also unusual. So that's a really, really strong case, but the problem is they have a judge who's really dragging her feet. And she's a relatively new judge, whether it's from inexperience or, as some suggest, because of bias towards Trump, who appointed her. She's just really taking forever on issues that shouldn't take that long. And it appears that case is going to drag out past the election. If it does, and of course, if Trump wins re-election, then with both of the federal cases, the assumption is he'll cancel them, right? He'll order his attorney general to just drop them. So we're in a really unique situation here, not just in the Florida case, but the January 6th case in D.C., the other federal case. We've never had a situation before where a criminal defendant might end up with the power to cancel his own prosecution if the case doesn't get to trial in time. So there's a lot of urgency in the D.C. case for the Supreme Court to decide quickly, and maybe that case can still get to trial before the election. But that window seems to be rapidly closing. Where it would be possible to get that done.
We've covered Eileen Cannon before, the judge down in Florida, who's making the determinations really on this timeline and the fact that she was a Trump appointee. What you're referring to with the Supreme Court, how they're hearing oral arguments on his absolute immunity claims in the next day or so. It's widely expected that they'll basically throw it out and essentially say, there's no way that a president can claim they have absolute immunity from prosecution because of the nature of the office. That's kind of very much against the spirit of everything that America was supposed to be about as an anti-monarchy constitution, basically. But the point is really what you say, is that they decided to even hear arguments, which delays all of this because of the fact that it's going to happen late April. Then they can't even get started until after this is decided. Right.
I mean, they could have taken it. I mean, Jack Smith asked them to take it immediately, to skip the D.C. circuit altogether and just take the case. That was back in December, I think. And they declined, but then they ended up taking it in February. And we're hearing arguments on Thursday. So they don't seem to be proceeding as though they see a lot of urgency. And in a normal case, that would be understandable. In a normal case, you'd say, well, it's not their fault, when the case came to them. And why should this be sped up just because the case didn't arrive to them in time? We should just take it in the ordinary course and we'll decide it like we decide any case. There's no reason to speed things up. But this is a unique case, like I said. We've never before had a situation where if he wins re-election and this case has not gone to trial, it's never going to go to trial. And the people have a right to have these charges tried, right? And the public has a right to a trial as well, not just the defendant. And because of that, they really need to step up and accelerate this decision. But they're not showing any signs of being willing to do that.
And then how does this affect the January 6th case, the other Jack Smith federal case?
Well, that's the one that I'm talking about.
Oh, okay.
That's the one where they're arguing the Supreme Court. The Florida case, that's just dragging on because of Judge Cannon. It's the DC case.
I'm sorry, I thought it affected both.
No, not really.
Okay.
No, it's it's appeal from the DC case that the Supreme Court's hearing arguments on Thursday, and of course that case has been on hold ever since Judge Chutkan denied his immunity claim. So that's the one, and that's the January 6th case in some ways, in terms of protecting our democracy and things like that, that's the most important case of all.
Right.
And if the Supreme Court doesn't act quickly enough and he happens to win a re-election, then that case may never get to trial.
And it's also concerning because the Fulton County case seems to have a lot of issues cropping up, given Fani Willis being quite reckless, honestly, with some of her personal entanglements. I know the right has seized on it, and it's not relevant, but you have to be very buttoned up when you're dealing with something that important for our democracy. I know this is not this is maybe a little bit out of your purview or what you focus on, but that's kind of I'm curious what your assessment is of that last major case that Trump's dealing with.
Right. So it's also based on the January 6th events, but even before all the distractions about the DA and the man that she hired being involved, even before that, this is just a really unwieldy case. 19 defendants, the state RICO charge. They've got another big RICO case going on in Georgia right now, where it took them months and months to pick a jury, and the trial itself is projected to last well into next year or beyond. Just because when you get that many defendants, and everybody's getting up to cross-examine every witness, and everybody's filing all their motions, and it's just an enormous, unwieldy case. So one of the things that was smart about Jack Smith's DC case, it was kind of a rifle shot. He charged only Trump, relatively narrow set of charges, gave himself the best possible chance of going to trial before the election. I think Georgia is just bogged down. It's just, like I said, very large and unwieldy case.
Too many defendants, too broad, but they would probably argue, how else can we make a RICO case without kind of expanding it to this broad conspiracy, right?
Right, but you don't have to make it a RICO case. I mean, you could have filed 3 or 4 separate smaller cases against different groups of defendants, for different aspects of the scheme, and really narrowed your focus. Or they could have filed cases just against Trump for now, thinking that they could come back later and get some of these other defendants. So, which is what Jack Smith did. I expect if Trump is not reelected, we're going to see more charges in DC from Jack Smith after the election, when it will no longer bog down his case. And he could indict some of these other 6 co-conspirators, separately in new cases. And you could have taken a similar approach in Georgia, but then instead they went all in, and it generated it was splashy and it generated a lot of headlines, but actually getting a case like that to trial is kind of a nightmare.
Well, really appreciate your time today and explaining this all to our audience and helping me out too in parsing this. Randall Eliason, you can read the blog Sidebars to keep up to date on this. And I saw you're also writing a bit about what's going on with Menendez and his trial as well, which maybe we'll have you back on to talk a bit about that. I'm from New Jersey, so I have a bit of a special interest keeping an eye on that. Randall Eliason, professor of white-collar criminal law at GW, former assistant U.S. attorney for D.C., and the blog is called Sidebars. Thank you so much for your time today. Really appreciate it.
Thank you. Thanks for having me.
All right, folks. We are going to head into the fun half shortly, but I wanted to not get past the free portion of this show on this news day without talking about this big news as well. I mean, of course, we mentioned it yesterday, but the escalation of these massive campus demonstrations in solidarity with Palestine, with the people of Gaza, demanding that their universities divest from weapons manufacturers, from contracts with the government of Israel, and more. Colombia kicked this off with the encampment that was met with a massive crackdown by the administration with the NYPD. That was not enough for someone like Tom Cotton, by the way, the Republican senator, who, if you find yourself agreeing with this fascist freak as a liberal Zionist, perhaps maybe check yourself and take a look in the mirror. He has called for the National Guard to be sent on these protesters, which is meant...
He loves doing that.
He really does. But remember when he said that in 2020 about Black Lives Matter protesters, and he took out an op-ed and the New York Times and it was met with outrage. Where's the outrage here? Because, well, there's less so, because the instances of anti-Semitism that, you know, I'm sure there are anti-Semitic incidents, but they are, by every account, extremely marginal. Extremely marginal.
We'll talk about that in the fun half.
But the headlines are dominating just those are dominated by just those marginal instances. Nothing about what they're actually asking for. That's the focus, and so you can have these like fascists like Tom Cotton saying these kinds of things, and there not be honestly the pushback that's necessary to meet this moment of the biggest crackdown on campus activism and free speech since the 60s. And I think Cotton calling the National Guard invoking Kent State was clearly deliberate, by the way.
By the way, victims of Kent State were Jewish. I think 3 of the 4.
As are victims of Columbia, NYU, and Yale's crackdown.
Disproportionately Jewish.
Disproportionately Jewish. The Jewish Voice for Peace activists, and Jewish Voice for Peace specifically targeted by the administration to cease their operations. So what was amazing, though, was as these demonstrations continue to grow, the faculty in these schools are demonstrating incredible solidarity with their students. And it goes to show that our education system, it's so deeply corrupt in ways, I think, that perhaps, you know, we all understand it, but this lays it so bare.
I mean, Robert Kraft pulling his money after Shea Davidai got his pass revoked. I mean, it says everything you need to know.
It says everything you need to know, that the administration is beholden, and the administrators are beholden to these massive wealthy benefactors who get to determine the direction of these higher learning institutions. And those doing the educating and the educated are really not the priority. And so this was just honestly a really moving display. You can see here how many faculty members walked out of Columbia in solidarity with the rest of the students. Because, yeah, it's not just crazy kids, the crazy leftist kids who are anti-Semitic. It's also the teachers, the scholars, who, when you really do scholarship and you really understand the history of Palestine, the immorality of the Israeli project is incredibly clear. So, of course, academia is going to understand this. And they also understand what it means to stand with their students. This was the crowd. There, some in there, you know, cap and gown. And this was a speech here, too, from another Columbia professor addressing the student body, Christopher Brown, who's a history professor, speaking to the students about his concerns about free speech.
Good afternoon. I'm Christopher Brown, professor in the history department. This is the first time I've ever held a microphone at a protest of any kind. I'm not sure whether that's something to take pride in or not. But I say it because this is not typical for me. I'm here because I am so concerned about what has happened at this university, with where we are now, and with where we are going. Thursday, April 18, 2024, will be remembered as a shameful day in Columbia's history. The president's decision to send riot police to pick up peaceful protesters on our campus was unprecedented, unjustified, disproportionate, divisive, and dangerous. are fortunate. We don't know how fortunate we are. We are fortunate that no one was hurt.
Yes, yes.
With that kind of show of force, with all those firearms, all it takes is one person to get nervous, a table to fall, a car or truck to backfire on Allen Amsterdam Avenue, shots fired. The New York Police Department does not belong on this campus except in dead moments of extreme And that show of force was a sign of weakness.
Yes.
Shame on her! In trying to show that they meant business, what they showed was their incompetence.
We can keep it rolling. That's what I was trying to say.
I want to say one other thing, and that's about the congressional testimony on Wednesday. And this is about academic freedom. It's also about Columbia. In 3 hours of testimony, the president of the university, to my mind, showed no pride in our institution. She said nothing. She said nothing meaningful. She said nothing meaningful about the virtues of this institution, of its people, of its faculty, of its staff, of its researchers, their dedication to excellence, their commitment to their students, the quality of the undergraduates and graduate students that we have here. The distinctive record of academic accomplishment and impact, the variety and rigor of the scholarship which is happening here today, the prospects for continued excellence. She didn't say anything about any of those things. She allowed slander of our institution to stand without rebuke. Soviet-style education, no response.
All right, I think we got a good... The whole speech is really worth it, honestly, so I wanted to keep it rolling a bit, but... yeah, I mean, there have been other professors from Columbia and Barnard who have spoken out essentially.
Some that we've had on this show. Adam Tooze has been great speaking out on behalf of this. Of course, Rishi Khalidi.
I saw some people recognizing professors that they'd had at NYU who were being handcuffed and walking out by the NYPD. In solidarity with their student body.
As a NYU grad, it is a shame that this morning they're putting up a wall in front of that. I don't know if I forget what the building names are, but yeah, just building a wall, very on the nose. And just to put into context, here's some other things about what are happening on the campus. United Nations Human Rights Office of the High Commissioner, after 6 months of military assault, more than 5,479 students, 261 teachers, and 95 university professors have been killed in Gaza, and over 7,819 students and 756 teachers have been injured, with numbers growing each day. And Solcon said this on Twitter, and this is my response to a lot of I think people in media, whether they're editors or sort of rapid response columnists, but Solcon says this: I think stopping to do tone policing or individual condemnations of random people at protests of a literal genocide is gravely irresponsible and conveys a lack of seriousness. Don't do it. It is never worth it, and any audience that demands it isn't on your side to begin with. And that is how I feel about all of this. It is not worth the time. If I was an editor for a newspaper, I would cover how thirsty Israel is for Jewish people to be victimized, so they can use it to as propaganda for an ethnic cleansing campaign way before I would be covering these incidents, which are the responsibility of local authorities. If there's anti-Semitism going on campus, that is the job for campus administrators. It is not a CNN news story. It is appalling that this is used up any time when people are being, like 18 more kids killed by bomb blasts the other day. It is pro-genocide maneuver that we're seeing. This is literally a psychological operation that many Zionists are drawing our attention to this bullshit.
They responded these administrators and administrations basically responded in unison. I mean,
coordinated.
There are well-funded groups that are basically sending out outrage threats to these universities, and they have the ability. The same groups that were doxing Harvard students and putting their information up on LED moving trucks outside of Harvard Square. There's a lot of money behind maintaining the war machine, maintaining our relationship with Israel for ideological and then also racist reasons. And then also, of course, Israel's a weapons manufacturer and trader and an outpost for U.S. interests in the region, and a destabilizing force, which some people benefit from. So there's a lot there, but the point here is that academia and people interested in educating others and those who want to be educated are standing and raising their voice, including many, many Jewish students, to oppose this. And it's an important moment in our history for sure.
And it's time to step up. Like all the professors, I've been so happy to find NYU professors speaking out about this, even ones that weren't at the actual protest. But we really need this right now. This is an absolute emergency. And we played that professor speaking at Spelman. I forget her name.
Ruha Benjamin.
Ruha Benjamin. Yeah. We need that across the board. And this is absolutely one of these times where it's not time to be silent.
With that, folks, we're going to wrap up the first hour of this program, the free part of this program, head into the fun half. If you would like to support the show, if you haven't subscribed already, we're nearing 1.5 million subscribers. Every subscription counts. That would be very nice if you were... It's costs you really no money. So if you want to subscribe to our YouTube channel, that's helpful. But if you have the ability and you would like to financially support this program, keep us independent, join themajorityreport.com. You can also go to shop.majorityreportradio.com to get our merch, our excellent merch. Bradley's actually rocking a Get Out the Void shirt today, along with his Knicks hat, which, I mean, just the personification of, I don't know. I was about to say of me, but that may be a little narcissistic because you're your own person. So this is our shop. Everyone should check it out. Become a member if you can. Join themajorityreport.com. Matt, what's happening on Left Reckoning?
Yeah, Left Reckoning, David and I talked to two uncommitted activists from New Jersey, your guys' neck of the woods. So that will be tonight at 7 o'clock Eastern Time on Left Reckoning.
And on ESPN today, I am unveiling my mock draft. Whew. I mean, watch out, people. These things always age well, right? But I'll give you some.
Football.
I'll give you some. Hey, no, then the rest of it is the NBA and the NHL.
Literally the amazing Knicks game and Ranger stuff going on apparently, and it's mock draft stuff.
It will be a healthy mix. A healthy mix. I mean, of course I'm talking about that Knicks victory last night. I'm going to talk about your guy Ant talking crap to his hero, the Timberwolves looking nice. Just the Damian Lillard popping off in that first half the other night. We'll also talk about the start to the NHL playoffs. That Islanders collapse last night was very sad. I feel for you Islanders fans. The Golden Knights stealing game 1 against the top seed in the West, Dallas Stars, and more. YouTube.com/ESPN show today. All right, guys. 646-257-3920. See you in the fun half.
You are in for it.
All right, folks. 646-257-3920. See you in the fun half.
Are you ready?
Who sent us this?
Alpha males are back. Boy is back. And the alpha males are back.
Just as delicious as you could imagine.
The alpha males are back. Boy is back. And the alpha males are back.
Just want to degrade the white man.
Alpha males are back.
I take all of it in my throat.
Alpha males are back.
Snowflake says what?
The alpha males are back.
You are a madman.
And the alpha males are back.
Oh no, Sam Seder! What a fucking nightmare!
Bring back DJ.
Yeah, or a couple of them, just put them in rotation.
DJ Danner.
Well, the problem with those is they're like 45 seconds long, so I don't know if they're enough of a break.
That's fucking nonsense. You see white people doing drugs, they look worse than normal white people, and all white people look disgusting.
And the alpha males,
psych, fuck them.
Snowflake says what? Snowflake says what?
A hell of a lot of bank. A hell of a lot of bank. A hell of a lot of bank. Okay, I'm making stupid money. Hell of a lot of bank. A hell of a lot of bank. All lives matter.
Have you tried doing an impression on a college campus?
I think that there's no reason why reasonable people across the divide can't all agree with this. Psych.
And the alpha males are back. And the Africans are black African. And the alpha males are black. And the Africans are back.
When you see Donald Trump out there, doesn't a little part of you think that America deserves to be taken over by jihadists? Keeping it 100. Can't knock the hustle. Come on, fuck them. Things I do for the bigger game plan. By the way, it's my birthday. Happy birthday to me, Jew boy.
I have a thought experiment for you.
And the alpha males are back. Africans are black. Alpha males are black. Africans are back.
Come on. Someone needs to pay the price for blasphemy around here.
I am a total pussy.
We are back, folks. It is the fun half. Gonna read your IMs here. Really quickly. Train Boy, have any professors resigned? Also, I don't know why more students haven't dropped out. Imagine paying $60K a year to be treated like shit. Well, it's hard to say. I mean, you're at an Ivy League school.
It's called the sunk cost fallacy, Train Boy. Like, having been in for that amount of money makes it hard to say, actually, I'm going to walk away at this moment and not take my degree that I'm into, 6 figures to users for.
The Ivy League. I mean, an Ivy League degree. It's tough. Like, these are kids too, and they see value in that. I totally get that.
Which HBCU is Biden speaking at again? By the way,
I'm not sure.
That's going to be. Was it Morehouse? Do not let that MFer speak, guys. And I think it's tough. It is tough because it's like, you don't want to throw away also the thing you're in debt bondage for. Although maybe they're at HBCUs, it's not as bad. I'm not sure.
Or, a celebration, I guess, for you and your family and making it about. But yeah.
But I don't want a genocide dare speaking at my celebration.
Totally.
Like, it's inappropriate. And like, it goes back to when he was in the South, and it's like, how dare you protest Biden in a church? How dare you bring this guy to a fucking church? Like, this is the situation. Like, we are not on defense here. Anybody who gets mad at you for how upset you are for the genocide being committed in front of your eyes, you get to point the finger. You get to say, thank you for nominating yourself for the next person. I'm